What's the difference between mens rea and actus reus? Now, those are two Latin terms that we learn in law school, but those are very applicable to every criminal case. You see, every crime has an act that's required to commit. So let's just say assault. The act that's required to be proven is some type of physical contact. Could be a punch, it could be a kick. That's an act that's required to be proven. Let's just take another example of larceny. The act is the taking of the item. Now, separate from the act, the actus reus, there's also the required mens rea to be proven, the intent that needs to be proven. So, for example, for assault in the third degree, which is an intentional assault, the district attorney has to prove that the punch, that the action was intentional. So let's take two different examples. Let's just say I'm spinning around with my eyes closed, holding my fist out, and I make contact with someone inadvertently. Now, that may qualify as a reckless assault, and we'll talk about that at a different time. But the intent to assault is not there. Let's just take the larceny case, for example. Let's just say I take something out of a store and I walk out, but I actually did not realize, I didn't even know. It was a complete mistake. So if I don't have the knowledge element to be convicted of a larceny, then you can't be convicted. Again, it requires both the element of the intent or knowledge, depending on the charge, and the action that's required. If the evidence fails to prove either of those for a particular case, then that must be a finding of not guilty.